what you're buying is the product of the design, not the design itself. The ownership of a design stems from the original design contract, such that if the original owner did not own the design, then any subsequent owner, unless that design is part of the sale and purchase agreement, will not transfer. So if you're buying a production yacht, for example, a semi-production yacht from, say, a Benetti or a Heeson, an owner cannot expect to own the design of the yacht that they've bought. All they have bought is the product. If it's a custom yacht, for example, again, you're buying the product of that design, because when the original owner commissioned that design, what they bought was a license to use that design in the construction of a single vessel. What you might have, however, is the right to have copies of those designs, and you may have a license to use those designs to repair the yacht or maintain the yacht, but nothing more than that. If you are a private yacht and you're operating within the European Union, on the acquisition of that yacht, if that acquisition takes place in the European Union and no tax has been paid on the yacht before, then VAT, that transaction will attract VAT. There's no way around it. I say no way around it, there are a number of very clever tax schemes which are not officially sanctioned, which from a certain point of view will allow you to avoid paying the tax. But those schemes are one person's view of the tax law, and it may not necessarily be the view of the tax authorities. There are other schemes which require you to sell and lease back the yacht, which are sanctioned, most notably in Cyprus and Malta. They both run structures which allow you to limit the amount of tax that you pay on the yacht, such that the effective rate of tax can be as low as 3% on an acquisition, which is significantly lower than 18, 19, 20%, whatever the effective rate of VAT is in the relevant jurisdiction elsewhere in the European Union. And in those circumstances, those are legitimate. Yes, there are people who believe that those are abusive structures, but those nation states, Malta and Cyprus, have officially sanctioned them. Interestingly enough, in the UK, HMRC, Her Majesty's Revenue and Customs, on their website are, although not absolutely crystal clear on the point, they give a very clear indication that they are deeply unhappy with those kind of structures where the only money that goes into the structure is the owner's money. And if there was a UK taxpayer who made use of either the Maltese or the Cypriot leasing structure, I could not guarantee to those clients that HMRC wouldn't tap on their shoulder and open that structure up to some further examination and possibly unwind it as an abusive tax structure.